So right now, obviously, as everybody knows, within the, we have two resolutions here. One is to authorize round affordable housing settlement Roper and settlement Leone. If you recall, we had our planner here last year to discuss the process of affordable housing and where we are. And we're also joined by Brian, who's also our affordable housing attorney. At this time, I would like to turn it over to our professionals to kind of just educate the public and the council of where we are within the process and why we're up against this deadline.
Thanks, Mayor. Maybe I'll kick it off if that's okay.
Sure, I think we should sit down now.
Okay. Do you mind, Mayor, if we sit?
Absolutely, please sit.
So, as the Mayor and Council will recall, the process of affordable housing in New Jersey was radically changed in March of 2024 when the legislature passed and Governor Murphy signed legislation that took it out of the realm of the Council on Affordable Housing and gave it over to the New Jersey Department of Community Affairs. As a result of that, they developed what they called a program, which is in the DCA, it's a number of retired judges who act as essentially as mediators in any disputes that come before the council, and special adjudicators who are planners that are also assigned. Every town that wanted to seek to have immunity from developers' lawsuits had to file a complaint by a certain period of time. Oakland chose to do that, as did the overwhelming number of communities in New Jersey. We filed and we got 4 objections. One from Fair Share Housing, which filed objections in over 400 communities, one from Roper, one from TDC Acquisitions, and one from Leone Brothers. So as a result of that, we've had to negotiate as a part of the program. What you sign up for is that we have to negotiate with all of them to try and come to terms. We have done that. It's been an arduous process over a number of months. They initially came in, the developers, with projects that, for whatever reason, the mayor and council we didn't think would be in favor of, and we've gotten them to modify them somewhat to make them more desirable. We now have, and you have in front of you, potential settlements with 2 of those developers. Roper, which is actually a development that was approved in your 3rd round. It's the same number of units. It's just a little bit different how they're going to take care of their wastewater. And Leone Brothers, we've managed to come to a tentative settlement with them. We have not settled with TDC Acquisitions. Despite our best efforts, we just couldn't get there. I'm not at liberty to say, Mayor, as you're aware, what those differences are because it was part of confidential settlement negotiations, but we tried very hard to reach a settlement with them and we couldn't. Fair Share Housing, we also don't have a settlement with them, but I think they just have decided they don't want to settle unless we settle with everybody else. So that's where we are. Hopefully the mayor and council will approve those 2 settlements. We will be winding up going to court on the other 2 that we haven't settled, and it'll go to Superior Court in Bergen County. In all likelihood, Judge Padovano, he'll get a recommendation from the program judge that was leading the mediation as well as the special adjudicator, and he'll make a decision as to whether or not our plan is compliant with the 4th round affordable housing requirements. If it's determined not to be, we're going to face developers' lawsuits, and I don't think the mayor and council or the people of Oakland are looking for that. So that's where we are in the process.
And this is all driven by state legislation, correct?
Absolutely, which, you know, is, as I said, radically different now than it has been for the past more than 30 years. Yes.
And what's important is not only is it radically different for a variety of reasons, the legislation also imposed very stringent and aggressive deadlines. If anyone remembers, I was here a little over a year ago giving a presentation on the legislation, and we
talk a little louder, please.
Sure. So I can be much louder. The legislation imposed very aggressive and stringent deadlines. And if you recall, I was here probably in springtime of 2024, right after the legislation was adopted. I gave a presentation on the legislation, and we had a whole slide with respect to the deadlines because they were so new and compressed. And it really has compressed this whole process into what used to be years into a matter really of months. Like for example, and I want to point out that the borough's been very proactive. It's met all of its deadlines, and we had to have a plan prepared and adopted by June 30th, which that was done. The planning board adopted it, the governing body endorsed it. We really only had a few months after our obligation was negotiated to that point to prepare the plan. Then there were 2 months two months for any challenger to submit a challenge. As Brian indicated, we had 4 challenges. So by September 1, we knew all our challenges, and now they all need to be resolved or settled by the end of the year, really just a few months. Or to Brian's point, there will be the next steps of a court process. It is all very compressed, and then the plan will need to be revised, and should we get to that point, that all needs to be done by March 15th.
March 15th?
March 15th.
Anybody from the council have any questions before we open up to the public? I'd like to give the public an opportunity to ask questions of our professionals.
I would like some clarification.
Councilman?
Can either one of you explain why the process is better to negotiate with the developers as opposed to going straight to litigation? And if you can explain how the process ultimately, going back to the 1980s, favors the developers.
Yeah, essentially, if we don't settle, a developer could file a builder's remedy lawsuit. And if that happens, and if they're successful in that, essentially, the court will throw out your zoning. And you will have absolutely no control over the number of units, the height, the number of stories. The court essentially undertakes all of those things instead of the mayor and council and a planning board. In the term of settlement, we're allowed to, and we have throughout this process for 4 months, we've been on this every week, several times a week, most of the time, with all of the borough professionals, trying to get the developers to come back with projects that are more suitable to what's already been developed in Oakland. And this way we have some control over the prospect of what's going to actually ultimately be developed. In addition to that, if we are not successful, then there is a builder's remedy, and a court were to ultimately find that we were trying to put up roadblocks, the same thing could happen here as happened in some other communities like Englewood Cliffs, for example, where they were ordered to pay millions of dollars in legal fees to the other side for trying to stop affordable housing.
Is there fee shifting involved in
There
this?
is, potentially there is, yes.
So not only could we end up with a poor decision, we can end up, the taxpayers could be end up with paying for the attorneys of these developers who I've sat in, you sat in on these meetings, they don't show up with one attorney. They show up with a few, 5, 6. Carolyn, can you speak to the fact that this process that was put in place this year, speak to the condensed timeline and how some of the rules that we were negotiating, while some of the rules were not even finalized?
Sure. So I did talk a little bit about the condensed timeline. I'll go through it quickly again. So
Speak up.
I'll go through the timeline again. Is this better? Can everyone hear me now?
Thank you.
The microphone's up in the ceiling.
So it's fine. So the legislation was adopted in March of 2024. In October of 2024, there were what was called draft obligations provided by the DCA, Department of Community Affairs. Each town that wanted to participate had until the end of January to declare what its affordable housing obligation for this round, this time period was. And that's what Oakland did in January. Then by the end of March, the obligations had to be resolved and determined. So that's January to March. And remember, this isn't just Oakland alone doing this. This is every town that's participating in the process. Hundreds of towns going through these same steps with their professionals, with the adjudicators, as Brian indicated, and with this dispute resolution program. So our obligation was finalized in March. We had to adopt the plan, which we did in June, literally months later. Then there was the opportunity for challengers to submit a challenge. Those were done by the end of August. So September 1, we knew our challenges. Those all had to be resolved by essentially next week, December 31. What the councilman's referring to, I believe, is although the legislation was adopted last year in March, there are rules that determine and dictate the types of units, the number of bedrooms, the sizes, et cetera. Those rules are referred to by their acronym of UHAC. And so we have been negotiating with challengers since September 1. However, the new UHAC rules were just adopted last Monday, December 15th. So it's impacting in multiple municipalities, some of the settlements, et cetera. So we're all working against the clock, so to speak, and sometimes you feel like you're on the bicycle going forwards, and sometimes you feel like you're pedaling backwards. And for that reason in particular.
I know, speaking of working against the clock, I know you have something else to do, but can you?
I have another meeting just like this I'm taking by Zoom, yes.
Right. So, but can you just talk about what's new with Round 4 is the regional need on how we as a borough, when we're negotiating what the state came forward with our obligation, how that formula worked. If they take something away from Oakland, it has to be added. So can you talk about how the regional need affects us?
So,
Were you ready for that?
affordable housing, just as a general principle, affordable housing, affordable housing is on the municipal level. Oakland has an obligation, Wayne has an obligation, Franklin Lakes has an obligation. However, the obligations all emanate from the regional obligation, and for decades, there have been affordable housing regions. We are in affordable housing region 1. Of all the regions, we had the largest obligation. So that sort of trickles down to its municipalities. If you think about it in terms of, if I have a pie, if I have a big pie, and we slice it up, maybe you're getting a bigger piece of pie. If I have one of those little fancy pies from some boutique bakery, only a couple people are getting bites of pie. That's how it works. So Oakland is in Housing Region 1. You had the greatest obligation, and I feel like it was in excess of 27,000 units that was distributed to municipalities throughout the region. I can pull up which counties are in the region. I'll get that. But every municipality has an affordable housing obligation except for what is called a qualified urban aid municipality. And of those, I believe there were 47 in Round 4. So that's the very short answer to I could talk for 2 hours about how the obligations
okay.
cut. And there are three different factors: income level, land capacity, and non-residential tax assessments that go in, that were averaged together, that were then applied to each municipality that determined its obligation.
Just finally, I just want to thank both of you. You've been a real asset, particularly for the last year. But can you just tell us, you just indicated you have another Zoom meeting just like this by Zoom. Brian, I know you represent a lot of town. I mean, how many of these have you done? How many clients have you been working on, each of you, for this year in this area?
I'm currently working, I'm Affordable Housing Council in 8 communities where I'm doing the same thing with the program, and it's a very arduous process, it really is, and for everybody. In fact, one of the problems is the state initially hired 9 retired judges for the whole state. There's 600 challengers out there.
Right.
I mean, there's just no way that it was going to get done in time. As Caroline said, though, various law firms have made motions to extend the timeline. They have all been thrown out. So they just want you to march ahead no matter what.
You, Carolyn, how many of these have you been doing?
I believe I was involved in the preparation of either 11 or 12 housing elements. So, and I have other staff members who have their own municipalities assigned to them.
Remarkably, you all got back to us on emails. There was never really a delay on any topic. Good job, thank you.
Anybody else from the council? Because of this topic, I'd like to have this open to the public. There's a motion open to the public.
So moved. Second.
All in favor?
Aye.
Anybody from the public wish to ask questions of our professionals concerning this affordable housing? Sure, step up by the table, and we just need your name and address. Yeah, that's fine, right there. That's good, yeah.
My name is Rick Hughes, Richard Hughes. I live at 32 Oak Street here in Oakland. My property is adjacent to the property that they're looking to develop. So far, we have not received any notification as far as this affordable housing. I thought if you were within 200 feet of a proposed site, you needed to receive some kind of notification about it.
Is this the Roper?
Yep.
Roper?
Yes, the Roper property.
Right, so Roper just was actually in your round 3 plan. So affordable housing is dealt with in a series of years known as rounds. And we function in a 10, for better or worse, in a 10-year round. So your round 3 plan included the Roper property. And all the plans, the housing elements, when they're adopted by the planning board, they have very specific notice requirements for that. But to your point, you're correct in that there is a 200-foot notice requirement for any board application. So when there is a point in time when the Roper property is being developed, there'd be something called a site plan approval that the planning board would consider. And you're correct, if you live within 200 feet, or I should say if you own property within 200 feet.
That's adjacent to it.
Right, you'd receive a certified letter.
All right. Can I ask you guys, was there a change in zoning on that property? It used to be B2, which was 8 units per acre.
Carolyn?
Yes, I believe that zoning was changed, the Roper, that zoning was changed as part of your round 3. I can try and get you the date of the
I
change.
think it was 2021.
21.
I thought it was 2021 as well.
If your question is, did the zoning change from 2021? No, it's staying the same.
It's staying the same as far as 8 units per acre.
No.
Whatever the zoning was in 2021, that's what it's.
What it was changed-
As of this challenge, their challenge for this round only had to do with how they were going to be getting sewer capacity. It is not changing the zoning. They did
Are
not
we going
ask
to
for it.
discuss here today what the sewer capacity, I know it was an issue because of such a large development. We're going to be discussing that today?
Well, so because of the situation that we're in with our obligation to meet with these retired judges and adjudicators, there's limited information that we can talk about as it relates to trying to resolve certain issues. But the borough is very well aware of what's required in terms of movement of water, whether sewage or portable. So,
This issue, Matt,
yeah, sure,
this issue had been brought up the last time they wanted to develop their property.
right,
They were going to run a line down West Oakland
right,
to Pompton with a pump house at Ramapo Valley,
right.
Ramapo River. God forbid that pump house failed. That's a pristine river. It would go into that river, it would go down into Pompton, it would hit Potash Lake, and there was a deep concern about it at that time. The next thing is, the size of the building that was proposed the last time,
Right.
you're saying it's still comparable to what they're proposing today?
I think that's the answer to that question is yes.
The
It's
same
it's
proposal.
identical, yes.
Yeah.
All right, because they had proposed a 4-story building with parking underneath the building. And they had a very shallow, as a matter of fact, that was one of their variances they were going for, something about the road going into it. Should one of the cars, because parking also was underneath the building, catch on fire, there's no requirement for sprinkler in the building. Should something happen like that, their egress for the fire department and medical and everything, emergency vehicles to come in, crosses the only exit road for the people who live there.
Yeah.
Yeah, it's a recipe for disaster.
Any approval that they get, and even if it's, if the settlement is approved by the mayor and council, they're still going to be required to go through site plan approval before the planning board. They're going to be required to submit their plans to all of our agencies to make sure the fire department signs off, the police department, et cetera. That can all be raised at the planning board. So they're no
Okay, so
different, they're
that's
not treated
here
any better than
now?
anybody. No.
Because I'm just
That's
looking at the size of the building, as it was then. It is so not conducive to the houses around it.
If, I will speak for myself in my official capacity, there is nothing about this since the 1980s, when I first read about the Mount Laurel decision in law school, that is remotely attractive.
Not at all.
Inappropriate for a community like us. At a joint meeting that Mr. Iowa was at, I spoke that this issue is not a Democrat or Republican issue, it's a community issue.
Yes.
And unfortunately, the Supreme Court of New Jersey, who were appointed by governors, have selected judges that believe in social engineering, in urbanizing our communities. That's what I believe to be accurate and true. It's not a position that I take on it legally, that's a separate issue. But I just don't think it's a good idea. And I don't think any, I
The
can't speak for
size of this project. You don't think
I don't think any of it's a good idea.
Thank you.
Listen, I'm facing
I
something.
agree with you.
I'm facing something
I
similar.
anticipated sitting in my backyard staring up at a four-story building.
Right.
All right, at the time, they proposed putting a berm across, 50 feet back from the property line, 8 foot high with pine trees. However, the problem with that is the runoff water would run into my property. I have septic.
Right. Yeah,
I think, I just want to bring the meeting back. I don't think there's anybody sitting on this dais that is particularly fond of this process and relates.
I'm glad of that.
Okay, and quite frankly, if you look at what's happening here, what you're witnessing and what you're watching is the end of single-family developments. Subdivision,
So-
it's over.
So I came up with a poor metaphor in a meeting, and what the governing body is facing. Do you ever see the movie The Godfather?
Vaguely.
Okay, there's a scene where they tell the band leader to sign a contract to make this guy the singer in his band. And he presents him the contract, it says sign, and he signs it. But what's happening is there's a gun to the person's head. The Mount Laurel legislation and case law is the gun to everybody on this dais's head and pointed directly at the neighborhoods that have to swallow these projects. It's an economic gun. It blows up. If the council doesn't try to
I
negotiate, we
can
lose our
understand the
control.
repercussions.
Yeah, and that's what we're facing. And so politically, people can run campaigns and say things, whatever they want, but at the end of the day, you still have to, as an elected official, you still have to vote and take the taxpayer dollar into account. And that's why I drew the attention, I asked Mr. Gibbon to talk about that if we don't engage in this process, we turn ourselves over completely to the courts and subject the property tax owners and the tax levies of this town to outrageous legal fees. Not just a bad development, but the extra cost. And it could be millions of dollars.
So from what you're saying, just so I understand,
Yeah.
we have to engage in this process.
Yes.
It does not mean this is a done deal.
I can't answer that because if we enter into a negotiation and we vote to support a settlement, it's a done deal on certain aspects of it. As other aspects of it, Ryan, you want to interject?
No,
Okay, did I-
to the gentleman's question, what we would be obligated to do, what the borough would be obligated to do, is make sure that the zoning permitted this. There are some things that the developer is going to have to do with regard to sewage and interbasin transfer water, but if they're able to do that, they would be able to construct the project, yes. We cannot put roadblocks up in their way.
The change that I'm looking at is, I believe zone B2 was 8 units per acre. You have 4.7 acres. That would be comfortable. 110 units is going to be very cumbersome for our neighborhood. It's going to be cumbersome for traffic, if we could do a traffic study. It's going to be cumbersome to the school, the additional children. It's going to be a problem.
I agree.
We agree.
We agree. We agree.
All right, there are several homeowners
Yes.
from Oak Street
Yeah.
here, and we strongly oppose the size of this. I understand it's somebody's property, I understand they want to develop it, but let's do it reasonably. Let's do it in a manner that it's conducive to the rest of the people that live there.
Like I said, I don't think you're going to find an argument from anybody sitting up on this dais. It's
I'd appreciate also one other thing, to be notified on things that come up. Because none of us have received any notification until we all found out about this, and we were in a flurry of phone calls to each other. Is there any chance you guys can just hit the people who have adjoining properties?
That would be part of the site, so to your, as you
I would
as you
appreciate
said, I think you started your comments by saying you didn't receive any notification. So when this application comes before the planning board for site plan approval, anyone within 200 feet is required to be noticed.
Are they asking for different variances according to what's on the books now? Changes?
So so just to clarify, and I think the administrator maybe was the one who had said this zoning, this is around 3 site, the Roper property. So this zoning for this property was changed, I think in 2021. I'm fairly certain it was in 2021, predates my time with the borough, right? So the zoning is already changed. So they don't have, I can't speak to what kind of variances they might be requesting because they're not before the
Yeah, I wasn't
planning
aware that
board.
there was a change made to it in
Right, so,
2021.
right. So the way that this whole process works, has worked and will work, is that when there's a settlement between the town and a property owner or developer, is that there will be a settlement agreement. In other words, it's a legal document stipulating what's agreed to, and then the zoning is changed. In other words, what is permitted on the property is changed to allow for whatever is what the developer is proposing, including the affordable units. That's how this process works in the state of New Jersey. So that, that's how the process works. So that's why I was just whispering to Brian a little bit. I didn't want there to be any misunderstandings. The zoning for this property has changed. This is around 3 site. I just want to make
All
sure
right,
that you're aware of that.
Yeah, I wasn't familiar that it was changed. I just
That's
recently
right.
found out about that. I'm trying to get familiar with the entire process.
Okay.
And that's the only reason I'm asking to be notified.
and that's why we're doing this.
Ooh, that's why we're here.
That's why.
That's
I
why
think
many of these people
it's
are
also
here.
important, you were talking about like a stream and fire issues and stuff like that.
Yeah.
Just as a general matter, these developments still need to get approval if needed from the State Department of Environmental Protection. They still have to meet all building codes. I think a 4-story building would require sprinklers.
But by the same token, what about simple things like the school? 210 new units, how many new kids is that gonna put right into the school system? I don't think they have the capacity for that.
Probably about
It's gonna be-
5 to 10.
It's hard to believe, but
It's
the
not part
mayor
of-
and council are not permitted to consider that, nor is the planning board.
I know, we went through this. We went through this
Yeah,
last.
counterintuitive, but that's the law.
That's-
All right, are they gonna take it to consider traffic studies?
Yes and no, mostly no.
So also to your question about how would you know what is happening next, I think I'm rephrasing your question. So I'm assuming you all found out about this from maybe there was a notice on the agenda or something about that the mayor, to his credit, has having us here tonight just to give an update. So if there's going to be an ordinance adoption, that's also put on the agenda. And then there's 2 readings for each ordinance adoption, and then the ordinance is also, in between the 2 readings, it's referred to the planning board. If there is any necessary revisions to the housing element and fair share plan, which I think there might be, that happens at a public meeting with the planning board, and I can tell you without a doubt, unless there is lightning strikes and there's some extension given to one of these deadlines, that will be done between January and March 15th, because that's the state imposed deadline. So those are the types of things that, would be
I
on the
understand you
agendas.
have an expedited schedule.
No, I'm just trying to say also these things are on the agenda, so you were asking how could you find out in advance of, the site plan application.
Right.
I just want to make sure that you're aware that these
Where
are.
do I find that?
So I'm assuming your agendas are.
You can find that on the website. It's under the mayor and council tab, and it's uploaded the Friday before the Tuesday meeting. All
Friday
the
before
resolutions
Tuesday
in order,
meeting.
right, so the meeting is this Tuesday today. Everything was uploaded on Friday for the public to see. The agenda, all the resolutions, and all the ordinances that were gonna be introduced or adopted.
All right. I hope you guys can bear with me that I just,
No,
These are
This
is why we're here.
questions.
I'm looking at a rental
Yep.
and low-income rental being built in my backyard.
I just want to, can I just cut you up? Ms. Ryder, do you have to take a call? You have to go when Mr. Gibble can stay here?
I can I have a few more minutes.
You have a few
but
more
thank
minutes?
you.
Okay, I
Yeah.
just-
I'm concerned about my property value.
100%.
I'm concerned about the neighborhood. We're looking at rental people versus people who own. There's a lot of concerns. I'm concerned about the triangular lot that's on the corner of this place on Oak Street that belongs to the town. Is that being sold to Roper or to the contractors? Or is that up for bid?
I don't think we've done anything with it.
But no, that's specifically not referred to. They may want to attempt to negotiate with the town over some.
Because that's the only way you're gonna get a road through there. One of the requirements in that was to get a road from Oak Street to Terhune.
Can
That's the
I,
only way you get a road through there.
can I ask, we have Assemblyman Bob Oth is our state representative, and we're in District 39. Bob, is there anything you want to add, from the state's perspective, in terms of what you have had to endure for the last 10 years with regard to this legislation? I'm imagining you oppose this legislation.
You are
Assembly,
absolutely
can you
correct.
just come up, stand up here by, say, around the microphone so people can hear you?
Thank you very much. I wasn't prepared to speak about this, sir, pleasure to meet you. However, I can tell you, the rounds of Mountain Laurel housing that have been presented to the legislature for a vote, the legislative team of District 39 has voted against it every single time. Most recently, in the last round, I was up contesting this on the floor of the Assembly, and I was speaking to the Speaker of the Assembly, who was the prime sponsor of the bill, and explaining to him that everybody in this neck of the woods has groundwater as a source of water, that the aquifers are being stretched to the max with the overpopulation that's being foisted on the communities here.
Just put the new filters in.
At a large expense, and they are making us with PFAS included in this also. The filters need to be changed with more regularity. The intensity of the filter has to be increased to do this, and that's more expensive. And the state is making us do all of these mandates without any funding, so that creates a problem also. But to get to your question, this has been a total nightmare for many of us in the legislature, because we see people who are in communities that people are fleeing from dictating to us how we have to develop our communities. And their people want to come here, and they're dictating to us how we have to develop our communities because they've destroyed their own. And that's basically what's happening.
I'm sure you fellows and gals, you know the traffic out there. When there's a ball game, when school is getting out, now put another 130, 100 whatever units on.
No, it's obscene.
Crazy.
Agreed.
Yeah, I thank you guys for.
Assemblyman, can I just ask a question while you have the resident here? Did this break down along party lines, this legislation?
Yes, I got to be honest with you. I haven't seen any Republicans, if you don't mind me saying, none of the Republicans in our caucus have voted for this. So, and we just lost 5 seats, so New Jersey's in a bad way, and I know the new governor is gung-ho for this too, so I don't know.
She's made it very clear.
Yeah,
And
I
so
don't
is
know what's
her
gonna-
nominee for Attorney General.
So the only thing I can tell you is,
Are we gonna be compensated for the loss?
your property value.
Yeah.
No, absolutely not.
Yeah,
No.
No.
Just like when government takes property.
but we wouldn't do it in the pristine outskirts of Oakland. We would only do it right here.
I wouldn't even say that. They'll wedge it in any place they can. So while you may feel a little bit aggrieved in that particular aspect of it, they're putting high-density, affordable housing, so-called affordable housing, but high-density housing for sure, throughout the area. They took a pristine golf course in Rivervale, New Jersey, and they took 9 holes away from it so they could shove that stuff in there. I mean, it's incredible what they're doing.
May I ask one question? You probably are familiar with it. Did the railroad over there, what is that, Susquehanna? Didn't they have an issue with an apartment being there also?
I'm not familiar with that.
Mr. Gilbert?
I'm not familiar with that.
No, they haven't come forward. I don't think they would, given the,
I think it was concerning the drainage.
yeah, well, if.
You're gonna have a very large macadam parking lot to compensate for that 100-year rain. and it's going downhill onto the tracks.
Well, as Mr. Gibbon adroitly pointed out, they still have to get certain approvals, all these projects.
All right, let's leave it go at that, and I guess this stuff can be discussed at a future meeting.
Planning board.
I appreciate that. Thank you.
Is there anybody else from your community that would like to
Uh,
ask a question?
Mayor, I'm going to sit down and
Yes,
just,
thank you, sir.
Sorry, Bob.
That's okay.
I just
Just let you know-
happened to see you here.
feel free to contact me if you have any questions regarding any of these issues. I can't promise the kind of result we had with the trucking and waste station, which we stopped in Oakland, which I'm happy to say we had a little input in.
Colloquially known in Oakland as the dump.
Yeah. So I'm happy about that, but I am absolutely beside myself that we are continually unable to put a halt on the excessive building that's being forced on you.
From Trenton?
By Trenton, yes. And if I had a little more time, I would go into more detail on what's actually the driving force of this. And it's been a plan in place for 50 years, but it has to do with altering the political sway of different parts of the state, and it's being done as a political move, unfortunately, to the detriment of all our beautiful communities that we've had for so many years. So it's unfortunate, but I'd be happy to discuss that with you at another time.
All right,
Thank you, sir.
Thank you. Thank you very much.
Nice to see you, Bob.
Thank you.
Anybody else? Please. Just need your name and address.
Ed Young. I live at 26 Oak Street. We're neighbors with these guys here. I want to echo everything Eric said. It was great. So I just wanted to give my opinion, just kind of make a statement here that we all live in Oakland. We all love this town. And one thing that wasn't said was, they just put this other complex behind the high school. Nobody's moved in there yet. That, in addition to if this goes up here, I just want to say the main street here, we're basically a one-road town.
Correct.
To get from one side of the town to the other. And I think that's going to become a parking lot. And I think when the reserve was put in, last time we were here, they said there was a traffic study done, and they said it wasn't, and the people on the planning board said that they said it wasn't going to be that bad. And they admitted, they said it was, our traffic got a lot worse, and the traffic study did not do justice to what the changes were.
I think it's pretty obvious if this thing goes in, it's going to be traffic.
It's going to be traffic, there's going to be schools.
There's going to be
it's gonna be-
schools, I mean, there's all kinds of repercussions, and
Our property value will go down, we know that, but I think everybody in town will feel that effect as well. I think it's going to be a town issue.
It's a community issue. It's not a
It is.
Republican Democrat, although
Right.
it is initiated,
Yeah.
as Bob pointed out, as Assemblyman North pointed out, going back to the 1980s